Hello and welcome back. In this lecture we're going to look at how negligence might apply in the professional environment. You'll remember from the previous lecture that in order to show that you had a claim, the claimant must show that he was owed a duty of care, that the duty of care was broken by the defendant, and that he suffered damage as a result. However, that damage could not be pure financial loss, as we saw in the Spartan Steel Alloys case. Now, that meant that if you wanted to sue your solicitor or your accountant, the chances are that the loss you suffered there would be pure financial loss rather than property damage, and therefore it was very difficult to bring a claim. Now, the lead case that changed all that is this case of Hedley Byrne versus Heller and Partners. Now, there's quite a lot of story in there, but I just want to pick out the key points for you for now, so please do take the time to pause the video and go back and read the details of the case. But in this case, we had a company called Hedley Byrne, who were an advertising company, and they wanted to give credit to their client, Easy Power. However, they were worried that Easy Power wasn't good for the money and may not repay them. So what they did, they contacted Easy Power's bank, who were the defendants in this case, and they asked them for a reference. Now, the bank did give a reference, but they actually had an exclusion clause in there as well to try and protect themselves. Now, when Easy Power became insolvent and couldn't repay its debts, Hedley Byrne were looking for someone to blame, so they decided to opt for the bank. So they blamed the bank for this. Now, the case went to court, and the court said that in a situation like this, where you have a professional acting in their professional capacity, i.e. as a bank, that was enough to create what we call a special relationship. And where there is a special relationship of this kind, there could be a duty of care. And that gave Hedley Byrne a duty of care, a basis on which they could hold the bank responsible for giving a negligent reference. Now, in this particular case, ironically, the bank had an exclusion clause, and as the case predated the Unfair Contract Terms Act, they could rely on that clause, and the bank actually weren't liable. However, what it did do is create the precedent for people to sue their accountants. Now, that resulted in a plethora of cases, and this came to a head in the case of Caparo Industries versus Dickman. Now, Dickman, who was a partner in Touche Ross. Now, probably draw you another diagram to help you understand this case. Now, in this case, we had a company called Fidelity, and it was owned in part by a company called Caparo. Now, Fidelity was audited by Touche Ross. Now, Caparo, who was already a shareholder in this company, had a look at the annual accounts, thought they looked quite good, and decided to increase its shareholding. So it actually bought extra shares, a new shareholding, in order to boost its ownership of Fidelity. It turned out that the accounts were wrong, and therefore Caparo was out of pocket. They wanted someone to blame, so who else? The auditors. However, the court looked at this case and they said, look, this is getting silly. They said, look, the duty of care that is owed by the auditors is owed to the company. Now, they actually use the word to the body of shareholders. What they mean is the shareholders acting together to exercise their control of the company. So if there is a problem, if the auditors have done something wrong, they owe a duty of care to the company itself, and it's the company that can bring an action, not individual shareholders. Now, the court went on to say that it was not reasonable to use accounts as the basis for making investments for speculative transactions. That's not why the accounts are prepared. So the reason they said this is because if you're an auditor preparing accounts, you don't necessarily know who is ultimately going to read those accounts. Therefore, you've got no way of knowing how much damages you could be on the hook for. You don't know who's going to sue you and how much they're going to be claiming from you. And the court said it was this lack of knowledge that meant the accounts could not be relied upon for investments. If you wanted to make an investment in a company, the court said you should do your own due diligence. So do your own checks, make sure the company is indeed sound. Now, slightly later on, there was another case where the company chairman had actually received a copy of draft accounts and left them lying around in his office. They were seen by a purchaser of the company, thought they looked good, and bought extra shares. He also was unable to sue the auditors because the auditors had no knowledge that this particular purchaser was going to be looking at the accounts and would be trying to rely on them. So again, he couldn't claim. Now, in a more recent case, a 2005 case, the courts revisited this point and they said, well, you know what? If you prepare audited accounts and you know who is going to read them and you know why they're going to read them, then it may well be reasonable for the accountants to be liable for any losses caused if they know that that third party is actually going to rely on the accounts. Now, in this particular case, accounts were prepared and they were used as the basis of obtaining loan finance from a bank. And the court said that it was perfectly reasonable for the bank to blame the accountants if they got the numbers in the accounts wrong, because they knew that the bank would be relying on them. And that point of law has actually come up in a couple of other cases subsequently. So, since the Caparo case, the courts have identified a number of situations where the accountants actually can be reliable. So, for instance, we've got the above example with the loan agreement, but also where the accountant has actually prepared accounts knowing that they are going to be used in a takeover. They're going to be relied upon to calculate a takeover bid. And again, in the Morgan Crucible case, the bidder had been identified to the defendant, so he knew who was going to be reading the accounts. He knew, he had knowledge about who it was intended would rely on the accounts. And he had actually made express representations to the bidder. So the auditors were actually in touch with the bidder. Again, in the Galoo case, the auditor had been told that the takeover was going to rely on the accounts, and therefore, again, because he knew who and why the accounts would be used and who would be relying on them, again, he was liable. Now, the ADT case there is a slightly different scenario in that in this case, the auditors didn't know who would be relying on the accounts at the time of preparing the accounts. However, slightly later on, the purchasers of a company, or the prospective purchasers of the company, took the audit partner to one side and had a meeting with him. And they asked him at that time, they said, look, we're ready to go ahead with the purchase of our target company. There's just one hurdle in the way. We wanted to have a chat with you and see if you thought that this was a good acquisition. Are the accounts reliable? Now, the audit partner, without checking the accounts, without making any further investigations, said that he absolutely stood by his firm's audit. Of course it was right, because he was the audit partner, that kind of thing. Anyway, it turned out he was wrong, and the accounts weren't correct, and although the investment went ahead, the investors lost a lot of money. Now, in this case, the court said that that statement that the partner had made, at a time when he knew who was relying on the accounts and why, was enough to create a liability for Binder Hamlin. So, although the knowledge wasn't there at the time the accounts were prepared, the fact that he had reasserted the values in the accounts at a time when he knew who and why they would be relying on the accounts was enough to create a liability. Now, a couple of other situations which, although they're not takeover situations, are similar. So both of them actually reflect a similar position. These are periods when accountants have prepared accounts for their clients, but a third party has still been able to rely on those accounts. And again, it still comes down to the knowledge of the accountants when they prepared the accounts. So in the KPMG case, the Law Society actually underwrite the client account of various law firms, so the money that law firms hold on behalf of their clients. If that money goes missing, the Law Society will reimburse the clients. And in order to help them with this process, the Law Society collect each law firm's annual accounts and check to make sure that the client account is being properly managed. In this particular case, KPMG did not notice that there were problems with the client account. The Law Society renewed its underwriting of the firm's accounts, and therefore, when a claim was made, it sought to recover that amount from KPMG. And the courts agreed. They said it was entirely foreseeable that an adverse accountant's report would result in intervention by the Law Society for the protection of the public. So the fact that they hadn't given that adverse accountant's report meant that KPMG were liable. The QONIS case is very similar, actually. It's another underwriting arrangement, but this time it was the Civil Aviation Authority relying on the accounts of an air travel company. And again, it was felt that the accountant should have known that the Civil Aviation Authority would rely on the accounts, and therefore, if they were incorrect, he could be held responsible for the Civil Aviation Authority's losses. Now, in exactly the same way as when we were looking at ordinary negligence, the claimant has to show that the breach of duty of care caused him to suffer loss. Now, the Jeb Fasteners case is an example of the but-for test defeating the claim being made by the claimants. In this particular case, the accountants prepared accounts. They were clearly negligent. The accounts were wrong. But again, it was the purchaser of the company that was trying to claim for his losses. Now, in this particular case, it was a takeover situation, so that duty of care may well have applied, considering the cases we've already looked at. However, the defendant could show that the claimant actually didn't go ahead with this transaction just because of the values in the accounts. He actually bought the company because he wanted to secure the director's expertise. He basically wanted access to the key staff members. And the evidence was, even if the accounts had been correct, the purchasers would have gone ahead with the transaction because they weren't really interested in the company, they were interested in getting access to its skilled staff, i.e. the but-for test was not satisfied. So, if we summarise this situation, there's a list of points there that you can learn for your exam. It tries to just distill some of the key points for you. We need to work out why the auditors have made their statement. Did they know who was going to rely on it, why they were going to rely on it, and potentially what their exposure would be? How much were they on the hook for? Did the professional accept that responsibility? Was it foreseeable that the claimant would rely on them? And is it fair that the accountant, the professional, should be made liable? Now, even if you can show all of that, it doesn't necessarily mean the accountant or the auditors will be liable, because an auditor can enter into a liability limitation agreement with his client, and this can limit his liability for negligence. Now, we know that the courts don't particularly like exclusion clauses, and this particular type of exclusion clause is covered in the Companies Act. It says that you can only limit your liability under one of these clauses to a fair and reasonable amount. Now, what is fair depends on the fee that you've charged. The bigger the fee, obviously, the more you should be on the hook for. The size of the company being audited, and the profile of that company. Is it a company in a risky environment? Because if you know that, you should be taking more care with the audit. Now, if you're going to have an auditor liability agreement, it has to be disclosed in the company's accounts, and also it has to be approved by the shareholders. However, the scope of a limited liability limitation agreement is limited by definition. So it is not possible to have a clause which completely exempts the auditor from liability. That wouldn't be acceptable. You can have an indemnity for your expenses if you successfully defend proceedings. So if the client sues you and it turns out the client was incorrect, it's only fair that you should be able to recover your expenditure there. It's worth noting also that it is a criminal offence for an auditor or for anyone else who provides information to an auditor to provide information which is misleading or false to a material extent. So auditors do have a legal obligation to actually make sure that accounts are correct outside of their contractual and also their liability under civil law of tort to their client. Okay, so that is professional misstatement. I hope you found that useful. The next lecture will be about defences.